Court will now call case number 125459, State of Kansas versus Jared Payne. Counsel. And I've noted your 3 minutes.
Thank you, Chief Justice. May it please the court, Lindsay Cornegay from the Kansas Appellate Defender Office on behalf of my client, Jared Payne. Thank God I don't have to address the Second Amendment and historical analogs. This case is primarily about a jury instruction issue and the district court failing to provide a requested jury instruction on causation. Because the district court denied that requested causation instruction, Jared was denied the right to a fair trial and the right to present a complete defense. Causation was the entire purpose of this trial, and the lack of causation was Jared's entire defense. Counsel was able to provide some evidence and argument as to the lack of causation, but it's different to have a jury instruction that sufficiently addresses causation and the issues of contributory negligence and superseding causation. We presume that juries follow the district court's instructions, and here the jury had nothing in front of them to direct them to consider UPS driver's conduct and whether that was a superseding cause or in any way contributory negligent. Here, the Court of Appeals agreed that this requested jury instruction was both legally and factually appropriate. So I don't think I'm really here to talk about that much today because there wasn't any kind of conditional cross petition on that. I think, I have the position that that was a legally and factually appropriate instruction. Here, the state has the burden to show that there is no reasonable probability that the lack of this instruction contributed to the outcome.
But the panel, I'm sorry to interrupt you, can I ask you, but the panel didn't conclude it was error not to give the proximate cause instruction. They said it would have been legally and factually appropriate, but the instructions given nevertheless adequately conveyed the law. So I read the Court of Appeals opinion as finding no instructional error.
Your Honor, that's correct that the Court of Appeals found,
At least on the causation instruction.
Correct, Your Honor. The Court of Appeals found that there was no error in failing to provide that instruction, but I disagree with that. I think there is error because this was Jared's defense and he has the right to be instructed on that defense. I don't believe that the jury instructions were sufficient. They did address a little bit of causation in the elements instructions. You had killing, you had reckless defined, you had for aggravated battery, the word caused, and you had knowledge defined, but that does nothing to talk about superseding causation, and that does nothing to talk about contributory negligence. So
I want to interrupt just real quickly here. The error you're getting at is that the instructions that were given don't cover the problem.
Exactly, Your Honor.
That's not the same thing as saying there was error because you asked for a factually and legally appropriate instruction and you didn't get it. The focus still moves to whether what the district court did covers the basis. See the distinction I'm making? It's not you don't get an automatic flag just because the defendant wants a factually and legally appropriate instruction. That fact alone doesn't give you error. There still has to be the failure of the instructions that were given to cover the ground that you want covered.
Yes, Your Honor. I think I'd see the distinction and the point that you're trying to make, and just that if I'm understanding your question correctly, yes, you can have a district court give instructions, and sometimes this court has held yes, defendant wants an additional instruction that maybe further explains things, and maybe it's not sometimes error to not give that instruction. But in this case, I am arguing that this is error to not give that additional information, because again, this was the entire defense. This wasn't the entire point of trial. There is nothing to talk about contributory negligence, nothing to talk about superseding causation in the instructions. As I mentioned, the state has a burden to show that there is no reasonable probability that the error impacted the outcome of trial. And this was not harmless error. I just wanted to point a little bit to the evidence that was presented during the trial. Ethan, Jared's surviving son, first gave a statement to the police the day after this accident. And Ethan said in that statement that the UPS truck cut off Jared or swerved at Jared, flashed his bright lights at Jared, was erratically switching lanes, yelling at Jared, that the UPS driver sped up when Jared was trying to switch lanes, and that caused the collision. The record sites for that are from volume 10. I've got pages 34, 52 through 58, pages 68. That might not be a full list of all the times that was mentioned, but that's what I came up with. You also had Jared's statements that were provided to the jury where he said the UPS driver was swerving at him and put on his bright lights. You have the UPS driver testing positive for marijuana. We had 4 witnesses. We had Ethan, we had the UPS driver, we had 2 FedEx drivers that were also on the road. And a lot of those statements at trial didn't exactly match up with one another. It was a factually pretty confusing case with a lot of varying evidence. The 2 FedEx drivers had slightly different versions of events, and neither of those drivers saw the moment directly leading up to the impact. They may have seen some moments prior to the point of impact, but they both said that they were in a blind spot. They could not see the moment that Jared's pickup truck and the UPS truck collided. So I think those points go to why this is not harmless error. You have evidence where the jury could have reasonably found that there was contributory negligence here. Maybe there is superseding causation, and maybe Jared was not guilty of this of these charges.
We've got case law going back longer than when I've been on the court. That says in these instructions, when the jury is told that they have to find that the defendant killed somebody, and in this case, your client, the instruction was that your client killed his son, that properly connotes the causation that you're saying doesn't exist here. Why is that case law wrong?
I would argue that although it does, I'm sorry to hammer this point again, but although it does address causation to a certain extent, it addresses proximate cause to a certain extent, it does not address contributory negligence or superseding causation. So yes, in some cases, it does sufficiently address proximate cause. In this case, it doesn't address all the legal concepts necessary to reach a valid jury verdict.
Are you? Oh, go ahead.
Is the argument essentially that the instructions as given failed entirely to even alert the jury that proximate cause was a required element?
Your Honor, I wouldn't say that it failed entirely to alert the jury to proximate cause. I think it did address causation a little bit. It addressed it briefly, but it just wasn't enough. It wasn't
Well,
incomplete.
proximate cause is probably not a concept that is widely understood by lay people who would make up a jury. It's a complex, not necessarily intuitive idea. Was there anything else in the instructions that could have alerted the jury?
Not to my knowledge, Your Honor, and I do agree that proximate cause can be a confusing issue. I know I've had half a semester in law school on proximate cause, and sometimes I feel like I still don't understand it. So if a court did want to provide more clarification on proximate cause. I don't believe that would be error necessarily.
Well, why does the court have to?
I don't necessarily believe that the court necessarily has to provide a further instruction on proximate cause.
Well, isn't that the very issue of this case? That's what you're arguing, that the court did have to provide the instruction.
Well, my argument is that the court had to provide this requested causation instruction that addresses contributory negligence and superseding causation. And yes, proximate cause does kind of factor into that.
Well, and maybe we were just talking past each other. I was using the phrase proximate cause just to encompass all of that.
Okay, so if I were to kind of address this jury instruction as approximate cause jury instruction, I think it is error to not provide it. Hopefully I'm answering your question.
That answers my question.
Okay, thank you.
And why doesn't the recklessness language in the instruction also cover the concerns that you've got here? Because it says that the jury would have to find that the outcome be a quote result of the defendant's actions, close quote. That again seems to communicate to me that we're looking to see what your client did to cause the death.
Correct, Your Honor. Again, I would agree that that does address proximate cause in a way. Yeah, it does. But again, it's just not sufficient to address that. Hey, jury, you also need to consider whether the UPS driver contributed to this at all, the surrounding circumstances, and whether there was a superseding cause. So again, I would agree that that does address proximate cause.
How does it address proximate cause? I'm not tracking.
I would,
In the minds of an ordinary juror, a reasonable ordinary juror.
in the minds of an ordinary juror, they are likely not going to know proximate cause, what that means. But I think a reasonable jury does know in general causation. Just thinking a little bit about the civil PIC instructions, there's not a civil PIC instruction that defines causation. It says the committee recommends that no instruction be given defining causation. So I think jurors have a rough idea of causation. They have some idea of causation.
Do you think that idea is limited to what I'll call common sense, but for causation? You did X, the chain reaction caused Y. That's a but for causation.
Right. I would say but for causation is included in proximate cause, and juries have a general understanding of proximate cause. Even if they don't know the term proximate cause, they have a general understanding of but for causation. And just the problem in this case, again, is that the jury instruction we requested wanted more than just proximate cause. And I see that I'm out of
Well,
time.
You may continue with these.
Thank you.
Why was superseding cause even relevant? Because as I understand the record, it's really is about proximate cause, because you just have two versions of events of what happened. I mean, there was only one event, right? When there's a movement and a clipping of the two vehicles. And it's really about who caused that, the truck driver or the defendant. I don't understand I don't understand this notion that there was a later event that could have superseded. It seems to me that it's all just one incident that happens and we have two versions.
Right, Your Honor, I guess I would just point to some evidence in the record of that in the moments before impact, like the seconds before impact, you had Ethan's first statement to police that said Jared was trying to get over and the UPS driver sped up while Jared was trying to get over, and that clipped Jared. So that, in my mind, the court can correct me if I'm wrong, I am not an expert in civil law and superseding cause, but in my mind, that would be a superseding cause that the jury could then find my client was not guilty.
And even if it's contributory negligence, is there anything in the instruction you think that explains that concept to the jury?
Your Honor, it does say in the requested instruction that contributory negligence is not a defense. And I think that's correct. Contributory defense is not going to be, or contributory negligence is not going to be a complete defense. That's explained in the instructions, but it is telling the jury that you can consider contributory negligence as a circumstance in the events that maybe my client is not criminally liable for that. Could contributory negligence be a little bit more defined? Yeah, but I think the requested causation instruction was sufficient on that. Thank you.
May it please the court, excuse me, Garrett Ralph, Deputy District Attorney for the state, Wyandotte County. Your honors, there are essentially two main arguments on this petition for review. One, that the district court was required to present the jury instruction for causation that was requested by the defense, and that also the appellate court should have taken up the merits of whether or not the statements of the defendant were knowingly made, because the appellate court said that there was no contemporaneous objection at the time of trial, and so therefore they could not address that issue. Now, that's essentially the two main arguments on the petition for review. Also, the supplemental brief addressed the last part about contemporaneous objections, so that's what I intend to focus on here today. Your honors, the argument that the PIC instruction should have been given because the causation was the entire argument of the defense is factually incorrect. That was not the argument by the defense attorney. In his entire closing argument, not one time does he say that Kelly White, the UPS driver, was the cause of the accident. What he says was, it's an accident. He says that he alludes to several things, the inconsistencies in Ethan's statements, in the Kelly White's UPS driver statements. He alludes to reasons why they might lie, that Ethan's statements were different, first when he initially talked to the police, and then after he had time to talk with his attorney, talk with his mother, the fact that he's suing his father, and that his statements have now changed. He alludes to that. He alludes to why Mr. White might lie, why he would dispute the fact that a blood draw came back positive for marijuana, and that he argued that there was uncertainty on where and how the point of contact occurred. He brings up and emphasizes the points that the accident reconstruction from the KHP could not say which lane it entered into, said that it occurred in both the left and the center lane, essentially, on where the point of contact was. Also said that there was rub marks on the tire. He concludes this was an accident, pure and simple. He argues it wasn't reckless beyond the norm by his client, simply was an accident. Nothing in that is an argument that causation was the entirety of the argument, simply the standard that the defendant was using when he drove.
Sounds like you're making you're addressing whether instructional error was harmless. Let me ask you about the instructions that were given and assess whether they were adequate or not. I find it interesting, just took some time and looked through PIC, Crim 4th, and if you look at 54.181, it's the elements instruction for involuntary manslaughter involving a DUI. And then PIC 54.190, the elements instructions for vehicular homicide. And those are really similar to the involuntary manslaughter theory here, right? Where you have a vehicular accident resulting in death due to some other circumstance, driving under intoxication in those instructions, and, driving recklessly in this case. But those two PIC instructions say that when there is a fact dispute on proximate cause, that the instruction should be given. So why wouldn't that same rationale hold true here, I guess is my question. That was a very long question. Hopefully you follow.
I do believe I did, Judge. There are a couple differences. One, on vehicular homicide, they also talk about a gross deviation from the standard in which the driver was driving, not just that it was, could have been reckless or that they caused it, but that it was what they did was a gross deviation, which is a little different than what it is for involuntary manslaughter.
Right. So in one case, it's a gross deviation that's causing the accident resulting in death. But here it's reckless driving that causes a vehicular accident resulting in death. But why does that make a difference when causation's in dispute?
On this one, causation was in dispute because what was the issue was the actions were actually in dispute of what was actually done. Whether or not the UPS driver sped up, whether or not the defendant jerked the wheel, as Ethan testified in his later statement. The reason this instruction didn't need to be given is simply because the jury was asked to determine whether or not Kelly White caused the death of his son. I'm sorry, Ethan Payne, Jared Payne caused the death of his son. If it was his actions that did so, period. He had to determine that he acted recklessly instead of knowingly. The reason they gave recklessly versus knowingly, because it was simply the facts of the case was that he acted recklessly, not that he intentionally or knowingly killed his son.
Well, as I understand the defendant's argument, it is that the broad causation language that was given in the instructions, caused the death of or killed, is insufficient to capture this idea of proximate cause, because proximate cause is essentially, I think, the idea that even if your actions are the but-for cause of an ultimate injury, they may not be the proximate cause. Sometimes that's even called the legal cause. Sometimes there's a distinction. Sometimes they're referred to as factual causation, legal causation. And I struggle to see anything in the instructions that would suggest to the jury that even if they thought that the defendant's reckless conduct was the but-for cause, the factual cause of the accident, they could consider this notion that there was an intervening proximate cause that cuts off liability. That's what proximate cause is. It's a theory that severs liability between an initial wrong action and an ultimate injury.
Yes, Your Honor.
So can you point me somewhere in the instructions that do that?
On these particular instructions, no, because I do not believe it was necessary, as opposed to one of the cases that was cited in the appellate decision on State v. Collins, where they did give an instruction similar to what was requested. And the reason on that case was given was, yes, the defendant in that case was driving drunk. The defendant caused the accident that killed somebody. It, however, was determined by the accident reconstructionist that the victim was parked in the middle of the roadway. It was a blind roadway or a blind turn, that whether the defendant was drunk or sober wouldn't have mattered.
So you're making an argument that this instruction was not factually appropriate, but I thought that is not in front of us.
I'm arguing that it was not required to be given. I'm not saying that it couldn't have been given. I'm saying it wasn't required to be given.
Do you concede that it was legally and factually appropriate?
I'm not sure I'm allowed to argue that it wasn't
I
factually
don't know that you
appropriate,
are
but
either.
no, I would not concede that it was factually appropriate. I thought.
Well, once we are stuck with the idea, with the conclusion that this instruction was both legally and factually appropriate. Once it's factually appropriate, I struggle to see how the jury doesn't have to receive it if it's not covered adequately elsewhere.
Well, under State v. Ziner, 316 can 346, 222, it says that a district court may modify or add clarifications to pick instructions if the particular facts in a given case warrant such a change. There are no cases that say it has to be given. There are cases, however, that say that it could be given and that they may do it. In this case, it wasn't given, and the appellate court determined that there was no error by not giving it. They said they could have. It was up to the judge. They didn't. Okay.
I think we usually say it need not, it may be given. And we focus on whether or not it is necessary to the understanding of the jury. And I think maybe what some of us are struggling with here is, were these instructions enough to tell an ordinary juror about the concept of proximate cause? And how would you say these instructions really relay that message to an ordinary juror that walks, just walks in off the street and hasn't had torts instruction?
Sure. The argument was actually made by my colleague on the other side. Jurors know causation. There's common sense as to causation. Did you cause the accident? Did you cause his death? Was it your actions that caused it? Sure, if the UPS driver had not been there, odds are this crash wouldn't have occurred, because there wouldn't have been anybody for Jared Payne to get in his road rage with, wouldn't have been anybody with Jared Payne's to antagonize or attempt to cut off. But he did. And so it was his actions, the jury determined, and it was his actions, not the UPS drivers, that caused the crash and therefore killed his son. The jury heard all this evidence. They were allowed to take it into account. The defense attorney made the argument that it was just an accident. He made the argument that all this stuff occurred, that there were inconsistencies, that he said you can't know for sure what it was that happened. So the jury made a determination on the validity of the evidence and the credibility of the evidence, and determined beyond a reasonable doubt that Jared Payne recklessly killed his son.
But were they told that there's a difference between being some form of a causative factor versus being the proximate cause?
I would argue no, that they were not told that it could have been a portion, as opposed to that he was the direct cause or the proximate cause. I would argue it wasn't needed. If you were talking about contributory negligence, again, as we know, is not a defense. It's not to be brought in. It's not to determine whether or not he was 40% liable in a civil case. Therefore, he's got to pay the 40%. It was just simply, was he the cause? And the jury said he was. There was no confusion on that issue, at least to the jury, and the appellate court determined as well.
What's the standard we apply if we find the instruction should have been given?
If the instructions should have been given, then I would say a harmless error analysis is where it would be the next step. That was the analysis that they were beginning to use.
And again, there is a little confusion here. We have a requested instruction that was denied, should have been given. What standard? We apply a harmless error, but what? Is it a constitutional harmless error? Where are we at with that kind of standard?
I would say that it's under a totality of the circumstances, looking at the evidence like they did in State v's salary that was later used, cited by the appellant, to say that it was on the state's burden to prove the omission of the causation instruction not being given. State v salary, actually, they went through the couple steps. They didn't say there was error. They actually just presumed it was error and said, all right, so we're going to look at that. And then if we assume it's error, let's look on whether or not it was harmless. And they said, based on the totality of the evidence, it was. The overwhelming evidence was that he was guilty, and State v salary was premeditated murder. It wasn't a reckless standard, but that's what was cited. So I would argue you would do harmless error. The evidence was quite a bit on, there was conflicting evidence on whether or not Jared Payne caused it. Yes, but there was quite a bit of evidence. The people who had no skin in the game, the FedEx drivers, their testimony was it was Jared Payne who was the aggressor. It was Jared Payne who was the one driving erratically. The UPS driver was not. He wasn't the cause. So while they could argue that it was a credibility issue with Ethan, with the UPS driver, it could easily just as be argued it was a major credibility issue with the defendant. And the state used also the evidence of the testimony of the FedEx drivers. And then
Do you think the proposed instruction that was not given would have adequately explained these concepts to the jury that we've been asking you about? Because it doesn't look like they define they use the term proximate cause, contributory negligence, and superseding cause without defining those concepts.
I would actually contend it would confuse the jury more. They don't, as you said, they don't define any of those three terms. We've all been up here saying that the jury doesn't know what proximate cause is, that attorneys who have gone through law school don't know necessarily what proximate cause is. They know about superseding cause, contributory negligence. The average juror is not going to. But what the average juror does know is cause. Did you kill him? Was it your actions that caused his death? And that's what they were asked to determine. I think if you add in jury instructions that then put in legal terms that even attorneys have issues with, and without defining them, I think you're just going to confuse it more than anything else. I mean, we give definitions for reckless and knowing and intentional. And those are common words that are used all the time. And we define that for the jury to make sure that they know. If you're going to add in a jury instruction that adds in legal terms that may or may not actually apply, I think at best you're going to muddy the situation. It appears as if I am out of time. If no further questions, I appreciate you hearing me. Thank you.
Thank you. Ms. Corrigan?
So first, I guess I would want to apologize to the court in case I incorrectly used any terms for proximate cause, superseding causation, contributory negligence. But I think that's exactly why we needed this additional causation instruction. I don't think this is something that the average jury is going to know. And it was imperative that they did have these concepts in front of them to accurately determine Jared's case.
Can I ask you just the question I asked the state? The proposed instruction says contributory negligence is not a defense. I'm summarizing. It's a circumstance that be considered along with other evidence in deciding whether or not defendant was proximate cause, or whether somebody else may have been a substantial factor and a superseding cause. Those, like, the legal concepts aren't really defined in the proposed instruction, are they?
You're correct, Your Honor, that they are not defined in the proposed instruction. And I don't think it would be error to define those a little bit clearer. I think those are concepts that the average person isn't going to know. And that if you have concepts that the average juror is not going to know, yeah, you might want to define those. I think I am just working off the instruction that we have, but to answer your question, I don't think it would be error to define those terms further, just to make sure the jury has a clear understanding of what's before them so that they can reach a valid verdict.
I think the question, though, is not whether it would have been error to do more. If we're wrestling with harmlessness, how does this fix your problem?
Well, Your Honor, I would just point to, again, some of the evidence that I outlined in my initial argument, that we had Ethan's first statement that was talking about contributory negligence, that was talking about maybe Jared didn't actually cause this accident. The state mentioned FedEx drivers witnessed parts of this accident, but they didn't see the moments of collision. They didn't see whether or not the UPS driver sped up into Jared, as Ethan had said in his initial statements. I apologize. Was I answering?
Well, no, because, I mean, we're struggling with the definition of terms. I mean, you said you went to law school and you still struggle with the term proximate cause, yet you're telling us it's error that they didn't read this instruction, which uses the term proximate cause but doesn't explain it. So, I mean, that's why I'm saying, how does what you propose fix what you're concerned about when it doesn't define the terms that we're wrestling with?
Well, Your Honor, I would say that it would be a better instruction to define proximate cause. It would be better, but this instruction does fix part of the problem that it tells the jury more about causation. Is it a perfect instruction? No, but it tells the jury more about causation. I see that I'm out of time, so I would just conclude my argument by saying this instruction was necessary to give a full understanding of causation to the jury. Without this instruction, the jury did not reach a valid verdict, and I would ask this court to reverse and remand. Okay.
Thank you. Thank you to both counsel for your arguments this morning. The court will take this matter under advisement.